So I'm going to call the meeting to order. So this is the Town of Lancaster Conservation Commission meeting of June 25th, 2024. I'll begin by calling the roll. Dennis Hubbard.
Aye.
Bruce McGregor.
Aye.
Jim LaValle.
Here.
And Tom Seidenberg is also here. I'd just like to begin by saying thanks, Jim, for running the last two meetings. I was away. I appreciate that you took that on.
Well, you're welcome. I had a great time.
Great job, Jim.
And I did listen to the meetings. You did a good job, Jim. Thank you. I see Dave Millett is on. Dave, we haven't had a chance to be introduced, but hi, I'm Tom. Welcome to the commission, or at least at next meeting. So good to see you on. Happy to have you.
Thank you very much.
So just as a side note for the folks who don't know, so while Dave is joining the commission, he's not yet serving. His term doesn't begin till July, so he won't be participating in the hearings today. Okay, so I see Matt Marrow. The first item on the agenda is a continued notice of intent for Zero Heritage Lane. Matt Marrow, why don't you bring us up to date?
Can you guys hear me okay now?
Yep, we can hear you.
Yep.
Okay, Matt Morrow representing Peter Christoph. So am I okay to share my screen?
Please do.
Can you guys see that?
Yep.
Yep.
Okay, so the last time I was here, essentially, Brad Stone and I, when we went out, we noticed there might appear to be some slight differences within the wetland line. So I went out and I reevaluated the wetland line previously delineated by Alton Stone. And what I found is if you look at wetland flag 13 and 15 and 16 actually aren't even on the lot. So it's 13, 14, and then what's going between 14 and 15. So 13, 15, and 16 did change. The original wetland line is shown on the plan. The relocated wetland line based on soils is shown here. And the only difference it made was we tweaked the replication area in the driveway above the replication area slightly. But the actual crossing itself, it doesn't impact that at all. It appeared to me that in looking at the line and reviewing it, it appears that Mr. Stone stopped doing test pits right around flag 12 for whatever reason, and then apparently relied on vegetation for the remainder, which was a couple of flags. So I'm assuming he probably thought he was okay. I looked at the remainder of the flags that also had test pits on them, and his wetland lines on those are dead on. The soils, the vegetation, the hydrology, everything there is dead on. So that's basically what I found. I know that I've been talking to Brad about having the wetland line added to the peer review. The only thing I didn't really care for in the updated status was they keep adding in examination of the notice of intent documents. The notice of intent documents that were originally submitted with this file are essentially moot at this point. The whole idea of the agreement that we came with the commission on this was to do a hydraulic analysis for the crossing to ensure that what was going on with the crossing, that the impacts were attenuated as far as hydraulic flow. Because of the difference in the wetland line between 13, 14, and 15, 16, the line was different there too, but it's well off the property, so it's not really a consideration as far as any work of the property goes. I don't have an issue with that. I just need to ask the commission that the supplemental, shall I say, scope just simply be confined to a site walk and an analysis of the wetland line by the peer reviewer in addition to the hydrology. That no one has any objection to. I'm trying to make sure that the scope remains pertinent and that the cost to my client who's paying for this individually and is not a developer winds up being, minimized. So the commission gets what it needs and my client's costs are reined in under control. I don't want to get this thing so caught up in superfluous efforts as far as review that isn't really going to generate any positive conclusion, that it just winds up being a waste of my client's money. And that's basically it. We've done all the adjustments on the plan. There's only some couple of adjustments in the wetland line. That's where we are today.
Okay, thanks, Matt.
You're welcome, sir.
Brad, do you have any comments?
Yeah, so it's been quite a while since we looked at
One
this.
second, Brad. Sorry. I think, Mr. Christopher, I think we're getting some feedback from you. If you could mute, please. All right, go ahead, Brad. Thank you.
Okay. Yeah, so I think the last time I looked at this project was really probably my second day on the job here. And Matt's correct. We did have discussion back and forth about revising the scope a little bit. But other than that, there hasn't been much to do until today. So we do need to get the scope finalized so that everybody's on board in terms of the commission, what they want. I wasn't here for the initial part of the review. So if there's something in that scope that the commission's comfortable in tossing out, then that's fine. We can have them revise that. I don't know, and I tend to probably agree with Matt. I don't know as though there's much that we need the peer review for to review the notice of intent application. If something may not have been done entirely on that in the past, I'm happy to go through the NOI document myself. So I don't know how much that might reduce the overall cost in terms of the amount of the increase. But I don't have a problem with reviewing the notice of intent application. As I understand it, the commission wanted the hydrology assessment done in terms of the driveway impact, and per my request, we added the delineation as part of the peer review as well. But other than that, I don't see any issues with what we were talking about in terms of getting rid of the NOI document review out. I think that's fair and fine. I can have the consultant give us a new quote and eliminate that part.
Okay, thanks, Brad. Commissioners, do you have any questions or comments?
Yeah, I do.
Go ahead, Bruce.
The big thing with me was the hydrology. So, I don't think that he needs to, the peer reviewer needs to review that other information, but the hydrology is the big thing for me.
Thanks, Bruce. Go ahead, Jim.
Yeah, thanks. The hydrology, that's the big thing for me as well. And the replication area as well. Its location and its construction. So, Mr. Mayor, are there two replication areas? It's been a while since I saw this plan, and we just got a new one today.
No, we have one replication area, and the agreement we had as far as the replication area, there's a 2,900 square foot. We moved here. We originally had it on two sides. So the plan does show where we formally proposed it and now where we are proposing it so that the commission had something to compare it to. We adjusted it to 2,900 square feet. You guys went through the plantings. You didn't indicate a problem with that. I think the hydraulic analysis would have to take the elevation of, it already takes what would happen with the wetland replication into account. It's going to have to by nature. So, I mean, as far as that goes, I think that's already an integral part of what would have to happen with the hydrology as it is.
Okay.
Because the hydrology is going to, it's going to include a constructed wetland and how that would hold post-development water back. So.
Yeah, I think I got confused by seeing that other replication area on the plan, the one on the left.
Yeah, I apologize. didn't mean to cause confusion. I just wanted to make sure you guys saw what was there before and what's there now to show you the changes. That's all.
I understand. So the final plan will not have that.
No, in fact, I'm having that taken off, but I
Okay.
wanted you guys to see for comparative purposes, what was done.
Okay. Thank you. I'm good.
You're welcome.
Okay, thanks, Jim. Dennis, go ahead.
Yeah, I'll just second Bruce. I'm good with moving the NOI, but the hydrologies definitely want to see that.
Okay, thanks, Dennis. My only comment is, so when we were out there for that site visit on Brad's first day or second day, I did notice that the area where the replication is planned for, there was a lot of surface water, and definitely seen surface water there pretty much every time I've been there on the site. So I think I've been out there at least twice, if not 3 times with you, Matt. Or maybe once independently. But anyway, so my question is, the wetland flag 14, did you verify on either side of that flag that it's not hydric soils there on the top of the plan there? I guess
Yeah, I did. Can you guys see my
west.
cursor?
Yep.
Okay. So essentially the original flag 14 has been unchanged. So my soils evaluations basically were in this area. Where I'm circling, they encompassed this area. So you had 14 went up, 15 that was here, I went up, or 13 rather, I went up, 15 I went up, 15 changed very little, 16 did change, but it's very far off the beaten path. And you're right, there's surface water mostly over here, more than there is over here. Surface water actually is off the property line. And what I was finding was there was an area of vegetation that was cut in another matter for whatever reason. I don't know if it was mosquito control that did it or whatever. The area over here that has a lot of surface water where I cut comes up this way. And, it looks like it's part of a wetland system. And like I said, I don't know if it was mosquito control or what, but it looks like it was right around the same time that this was cleared out. But yeah, this area here, I did go through all the soils here. I also went through all the soils here up in this proposed replication area. I went through everything. This area was very tough because it was very thickly grown, but I managed to find a lot of areas. I found his old test pits, went around those because his test pits are actually marked. They're marked all the way up to flag 12. So you have wetland flags and then you have test pits above, showing where the non-hydric soils were. So I did check all of these areas out above and above the test pits. And that's what I found. I found that his soils work was excellent right here. I mean, it was excellent. It was dead on. What he's finding for upland soils here is basically what I'm finding up here. Why he stopped here, I don't know. There must have been for his own reasons. Maybe he felt the vegetation that he was seeing here at the time, because I believe he actually flagged this before this area over here was altered. So maybe what he saw was a little different. I can't answer that question, but I can tell you the work that he did here was dead on. I just found areas I needed to refine here.
Okay, thanks. Any further comments or questions from Brad or the commission?
I have another comment, Mr. Chairman.
Sure, go ahead, Brad.
So just to touch base on, I think it was Jim's comment with the hydrology. So with specific to the replication area, that hydrology, I don't believe is part of the analysis and the peer review. I do know when Matt and I had initial discussions about trying to do or propose what's absolutely necessary here beyond what we don't think we can do in-house, and revise the peer review scope that way, that I was, at least on my end, I was comfortable with reviewing the replication area for the commission. So in terms of the H&H analysis, the replication is not included in that. But at the same time, I'm confident I can review the proposed replication and see if it's going to meet the performance standards, if that helps.
Okay, thanks,
Yes.
Brad.
Thank you, Brad.
Bruce, you had your hand raised. You have a question?
Yeah, thank you. So, first of all, thank you, Brad, for that. I think one of the reasons why it was important to have a peer reviewer look at the replication area was when this meeting first started, there was a lot of neighbors very concerned about this project to begin with. The other thing too is there's a lot of other factors beyond this property that caused a lot of issues within that whole area. There was, water coming down from George Hill Road. There was the mosquito work that was done. So I think the reason why we brought up the peer review to begin with was to just make sure that the replication areas are going to hold. And so when you guys were just talking about, not having to have them look at the NOI and just do the hydrology, I was assuming that the hydrology was going to tell us about the replication area. So I think that is important to have the peer reviewer, let us know if he thinks that replication area is going to hold. I mean, I've been saying all along that I think that the stuff that Matt has done and all the things, all the changes that they made, they were very willing to make a lot of changes to help support having this be the best possible solution. So I trust everything that Matt has given to us. The peer review is less for me and just more for the fact that this is a very sensitive area and to have the peer reviewer check on that replication area. So I'm not sure how much that's going to increase the cost. I would think the hydrology would be a big part of that, wouldn't it?
Are you asking me, Commissioner?
Asking either, maybe I'll ask Brad. Maybe that might be the best person to ask.
Sure. So in terms of the way I understood it and looking at the peer review scope, so the hydrology was more or less to make sure your post-construction conditions met your pre. So typical concerns for abutting property owners is that you're not going to be subjected to increased runoff, for instance. And that's kind of the gist that I got from how that was initiated, was to make sure that there weren't going to be continual or increased water problems from this particular project once it's constructed.
Yeah.
So the hydrology for the replication area, so I'll backpack a little bit. So the H&H study that's done is for the entire site. So it would encompass all areas of disturbance. So whether it's your driveway, your house, your replication area, any change in the landscape. So everything's looked at. So that the question that I thought that Jim may have been getting at with his comment with respect to the hydrology for the replication area was more specifically, would it be constructed at the appropriate elevation, for instance, to support wetland vegetation? Is it going to have groundwater, roughly within 6 inches of the surface of the ground? And are you going to get a thriving growing area there? So that's kind of what I was guessing was the comment regarding the hydrology. So that portion of groundwater hydrology, I'll call it, I can certainly look at, as I mentioned, but the hydrology study that was requested is more the basically the stormwater analysis that you would typically do. So that's going to look at what are the post-construction impacts versus the pre, and try to make sure that the posts don't increase, for instance. So I think he did mention, peak runoff and other things would be attenuated in there. So I hope I didn't further confuse anyone, but
No, that's great. Now I completely understand that's what I'm looking for. So if you were to do the analysis of the replication area to make sure that you think that things are going to grow well and those things, I'm completely 100% good with you doing that, Brad. Mine was more just about the runoff and making sure the replication area is going to hold, so that way that we're not having streams of water coming down because of the project. I mean, there's been water coming down there before the project, which is a whole separate issue. But no, that's the biggest thing I wanted to make sure is that the hydrology report's done, and you said that's going to cover the whole property, just to make sure we're not looking at additional runoff based upon this property. So I'd be good with that. Thank you.
Thanks, Bruce. Thanks, Fred. Any further comments, Brad or Commission? Any comments from the public? Not seeing anything. So Brad, I think, correct me if I'm wrong, the next step is to finalize the peer review RFP, if that isn't already finalized, have that sent out. Does it need to be updated based on this conversation, or is it basically all good to go and we can just send out the plan? Are we ready for that?
Well, I think as I understood, and Matt can correct me if I'm wrong, but there is the language in there about regarding the notice of intent document. So if the commission was okay of removing that portion of it, and then we'll see if the price, if that adjusts the price at all. You would think it would probably come down a little. How much, I don't know, but that's the one component that I've read into this.
Commissioners, does anyone object to removing that part of the review scope?
Nope, I think that'd be fine.
No, I think that's fine. I think we should also just update the second bullet where it says site plan submitted with the NOI, because we want to do it based off the updated site plan, correct?
Correct. We would want the updated site plan. Yep.
But with those two changes, I'm good.
All right. So at this point, I think Brad and Matt, if you know what the next steps are, I think we're just up for a continuance, right?
Yeah, I mean, I'll talk to Brad probably tomorrow, so we can just review the scope again. And then he can get me something like a refined quote. And that type of email stuff I'm going to be away on vacation, but that type of email stuff I can do. So if it comes in next week before the 4th of July, I can at least respond to that. Yeah, so I think we're good to go.
All right. So for continuance, do you want the next meeting or following? So our meetings are July 9th, July 23rd.
I'd rather have the 23rd. The reason being is once we agree and get the scope done, the person's going to want to come out there. So I'm going to want to go out there, get together with them, get any initial comments addressed, and have everything done and ready to go for your next meeting so that you guys have comments. And this isn't something that's a heavy lift for them. So it shouldn't take 2 months. You know what I'm saying?
Yep. Sounds good. So happy to take a motion to continue to July 23rd.
Yeah, I'll move to continue this to July 23rd.
I'll second.
Great. Motion's been made by Jim, seconded by Dennis to continue to July 23rd. Any further discussion? Seeing none, this will be a roll call vote. Dennis Hubbard,
Aye.
Bruce McGregor,
Aye.
Jim LaValle,
Aye.
and Tom Seidenberg also votes aye. All right. Thank you, Matt.
Okay, folks, thank you very much. I will see you soon.
All right. Next up on the agenda, we have continued notice of intent for 10 Fire Road 54. I see a lot of people on the call. I don't know if Bill or council wants to start the discussion, or somebody want to bring us up to date, or shall I start the discussion?
We can start on this
Sure.
one.
Sure, go ahead, Bill.
For the record, Bill Hannigan with Hannigan Engineering. We've been working with the Quills on this project for some time. There's been some back and forth as I don't want to totally recap everything that's going on. I think people that are here understand what's been reviewed and what's been submitted. Just prior to the last meeting that we attended, there was a letter submitted on behalf of the abutters, Mr. Bowen. And that letter, well, we didn't really have time to review that prior to us responding. Since that time, counsel for the Quills has reviewed that information and submitted his own letter. I think tonight what the commission probably needs to do, in my estimation, would be to take in the information because it's been submitted. Now it's on the record. And then from there, I think the commission maybe lays out their review, what they've done thus far in the review, where they feel the two parties lie relative to the matter of what areas are we allowed to rework on the site, and then from there we can let those who know more about the legal aspects of this than I chime in, and then from there my hope is that we can resolve the discussion. You know, it would be great if we could do it tonight, but if not, then we could resolve it over the next meeting or so, and then from there we would then step back in and make any adjustments to any of the plans that have been submitted for final review by Brad. But I think right now it's kind of in the review of the legal aspect of the project for now.
Yeah, thanks, Bill. I agree with you. You know, my goal for today's meeting was to get an understanding from the commission how we will view the exemption relative to this project. You know, I'm hoping to by the end of the discussion tonight have a pretty clear idea. Maybe we won't be settled, but I'm hoping we'll have a clearer idea of where commissioners stand on this. Because reviewing the plan, yeah, I mean, and talking about changes is kind of pointless until the commission, you know, at least comes to tentative agreement on how they view the exemption.
And just to point out that there are, as noted in Attorney Nyland's letter, there actually are two parts exemption is cited in two different locations, and I think that I'm going to hand it off to Attorney Nyland to kind of review that, and then I think that would be the next step in the discussion to help the commission.
Sure. So I'm happy to hear from both counsels. I'll start with applicant's counsel. So Attorney Nyland, if you want to lay out your letter, that we're happy to hear your thoughts.
Yeah, thank you, Mr. Chairman. Good evening, members of the commission. Chip Nyland, attorney on behalf of the Quills. I was brought into this matter sometime after the ORAD had been issued and after the notice of intent had been filed, when Jeff Roloffs had filed his letter and issues came up with respect to the two exemptions. And I think I can, the purpose of my letter was to walk through those exemptions because, as Bill indicated, how the commission views the application of these exemptions is going to paint how the project goes forward. So the first exemption, which I think is probably the most relevant and is the easiest, and because it was included in the ORAD, is the vernal pool exemption. So you brought in a peer reviewer, Brian Butler from Oxbow, who went and walked the site as well as we had. And we submitted a plan that's referenced in my letter, referenced from Bill Hannigan, which was an ANRAD, which, as you know, is the application for an ORAD to determine what the delineation of the resource areas are. They determined, everybody agreed that the isolated area was not an isolated land subject to flooding because the watershed wasn't large enough and there wasn't enough water generated to be an isolated land subject to flooding. But they did look at it as a vernal pool. And as you know, the bylaw regulates vernal pools differently than the Wetlands Protection Act. In the Wetlands Protection Act, the vernal pool has to be in a resource area, BVW, or in land subject to flooding. Those are the two most common. Your bylaw, which is similar to other bylaws in the Commonwealth, you regulate the vernal pool itself, regardless of whether or not it is certified or regardless of whether or not it is actually in a resource area, because you call the vernal pool a resource area itself. That is a major distinction from the way the Wetlands Act regulates it. So what Bill and the Quills did is they put a plan together and asked you to identify the resource areas and to confirm the resource areas. And the definition of a vernal pool, as I've indicated, is the boundary of the resource area for vernal pools shall be 100 feet outward from the mean annual high water line, defining the depression, but shall not include existing lawns, gardens, landscaped, or developed areas. So what the Quills did is they submitted a plan and they showed where that vernal pool was and where the lawns were and the appurtenances. They submitted it to the commission. There was a review by the peer reviewer, and in August of 2023, you issued an ORAD, which is an order of resource area delineation, that confirmed those resources. Now, two things were very important. One, Brian Butler agreed that there was a difference. It didn't matter whether the vernal pool was certified. He agreed with the way that I look at it. That vernal pool is under jurisdiction, whether it's certified, or not. And second, there was a portion of the site that was not included in that ORAD, but that has nothing to do with the vernal pool. So you have an ORAD that establishes, and that's in my letter. What the engineer did for us is he shaded the area, and it's my Exhibit 3, which is part of my submission, that shows exactly where jurisdiction is and where jurisdiction isn't. So we believe that the ORAD controls as to where the vernal pool is for purposes of going forward with the notice of intent. And again, it has nothing to do with what was there in 2007 or otherwise. It's the way that was agreed by the commission as the ORAD in 2023, and that's good for a period of 3 years. So then that is the resource area delineation that we used when we went forward to design the project. The second exemption, which is under, I think, 205, is much more difficult in terms of just determining exactly what applies or doesn't. I think it's usually a question of fact. The exemption reads, and this is again, I sat on my commission for 9 years, and I was involved when we wrote our bylaw. I'm up on the North Shore. But what you do when you write these bylaws is you make sure that you're not going to hurt anybody has an existing use. And that's important for whether you're going to town meeting or otherwise. And I think that's what took place when I read the section. It reminded me of the way that most bylaws are written, is you sort of freeze what's taking place in the area at the time that the bylaw is adopted. And they said, what the bylaw allows is the alteration of any residential, business, or institutional building or customary appurtenances, such as lawns, landscapes, and other developed areas, where such structure or appurtenance existed prior to the effective date of this bylaw, shall not be subject to the bylaw, but shall be regulated under the Act. So you don't get a free pass if you're looking to do work in an area that was developed prior to the 2007 bylaw and is still there. You have to go under the Wetlands Act, but the setbacks and all of the other provisions relative to the bylaw do not apply. Now, my reading of the ORAD is that the commission did not make any findings relative to that exemption. Your finding only related to the vernal pool, and not to this exemption. So any argument that we have, and I've said this to the Quills, and I think that's very clear, any argument relative to the application of this exemption, that burden is on us to show that the activity was in place in 2007 and the alteration is of something that is there today. So that's not included in the ORAD. So my conclusion is that as far as the design is concerned, we've shown you the area that is the vernal pool which you confirmed in your ORAD, and we can use that for purposes of design. And any other portions that were in existence as of 2007 can be altered, provided that they are still developed at this stage. So that's I think that's all I have now, and I'm available to answer any questions. Or Bill, if I missed anything that is necessary to address, let me know.
Well, I think just to touch on that, I think that the objective is that I don't think that the application is reliant on any of the 2007 exemptions at all. I think, and that's not the intent. The intent is that the application, the ORAD, defined the location of the resource areas, and the definition of the resource areas within the town of Lancaster's bylaw is 100 feet from the vernal pool, excluding those areas mentioned in the bylaw and mentioned in Chip's letter. So I want to be clear that we're not anticipating any protection under the 2007 provision. We're basically stating that the work that we're proposing is within the areas that are within the vernal pool resource area, which includes the 100-foot from the edge of the water or from the bank. Within that resource area, those areas that were previously, however it's defined within the regulation, altered, disturbed, grass, lawn, etc., that those areas are the areas that we are claiming stake to, that we have the right to continue to use and benefit.
Yeah, thank you for that clarification. I think I just want to make sure, since you introduced the fact that there were two different exemptions, I want to make sure that I addressed that, and I want to make it clear that that wasn't one that we were relying upon. Thank you, Bill.
All right, thank you both. Jim, you've got your hand up. Go ahead.
Thank you. So I have a question. So if we were to stipulate for a moment that the exemption applies, for the sake of argument, the vernal pool is still a resource area, and that is jurisdictional. So under the definition in the bylaw of alteration, it's incremental activities having a cumulative adverse impact on resource areas. So does the project have a cumulative adverse impact on resource areas? And I don't think that has been answered.
Yeah, if I can, through the chair, I can answer that question. Yeah, I'm just looking at the question of what the exemption applies to and where the vernal pool is. You're absolutely right. Once you establish a resource area, the fact that a portion of that area may not be included doesn't mean that the remainder of the vernal pool is not subject to the performance standard. You're absolutely right. We have to demonstrate that the work that we are performing in the buffer zone or otherwise is not going to affect or alter that vernal pool, which is a wetland resource area. So that's in front of us. I was taking care of dispensing of the legal question first, and then we'll go to the question of meeting the performance standard. That would be second. I'm a lawyer, so I'm not going to pass judgment on that second point. But we will. I mean, we have people that will do that.
Is there a way is it okay if I share my screen just to bring up the exhibit that Chip is talking about?
Sure, go ahead, Bill.
So within the letter, what we did was we took, this is a section of one of the sheets of the ANRAD plan, or that the ORAD plan that's now approved, and what we're trying to deal with is the area that we showed on our plan as being the red line here, the dashed line. Those are the areas that we stated on at the end of the ANRAD when we did the final plan, and this is from the final plan, that those are the areas that we were calling previously disturbed. And I know there's a question of, what definition or how do you label that? Well, that's how it was labeled on the plan. So I'm going to run with that for a moment. The vernal pool buffer zone is the grayish line that goes around like this. I'm sorry, the vernal pool resource area is this area out here. The vernal pool itself is here, then 100 feet off from that becomes the resource area. So by the commission approving the ANRAD and issuing the ORAD stating this is the resource area, those areas within the definition of vernal pool are then further defined by the dashed red line that we had, which we've now shaded to illustrate where we're saying that is. Okay, so I think that's where we need to get from the engineering side of it. We have submitted a plan. Okay, once we either agree or disagree on this shaded area as being an area that's previously disturbed or previously developed or previously grass or previously something, but part of the vernal pool definition exemption, not part of the bylaw exemption. I think that's where the clarity that we're looking for. We are saying that we're not exempt from the bylaw exemption, which is in 205. What we're saying is that there are areas within the resource area of the vernal pool that have exemption capabilities. And then once we agree on the line in the sand, if you will, on this sheet that's up in front of us, what we can then do is look at our site plan and see how the two overlay and see what adjustments that we need to make to satisfy the commission relative to those particular construction standards and those construction uses on the property within those areas. And there's opportunity to make things better as well. So that's one of the things that we want to be able to do. But for us to be able to, we need a starting point, which we thought we were getting from the ANRAD. That's why we did it. We were happy to go through the whole process, but now we're backtracking to the ORAD issue relative to what is the vernal pool resource area, and per your definition, it's not just the pool itself; it's the 100 feet beyond it, except for those items listed in the definition. So that's where we're at from the engineering side of it, Jim. That we're trying to get to that. So as far as the bylaw exemption, we're not asking anything about the bylaw. We're not asking for an exemption from the bylaw. We're subject to the bylaw. Yeah. What we're stating is in the definition of the vernal pool, there's portions within the vernal pool jurisdictional area, which includes the pool plus 100 feet, that we have the rights to some exemption capabilities. What those are further defined, but we need to agree on this first point first. I hope I didn't make it more complicated.
No, it's clear.
Okay, thanks, Jim. Bruce, you have your hand up. Go ahead.
Yeah, so unfortunately, I wasn't able to make the site visit. I know there was a site visit done quite a while ago now. I'm not sure if anyone that was on the site visit can speak about, the lawns, the gardens, all of those items, and if they thought they were, areas that were, currently in use now. I think, Tom, you might have been at that. I'm not sure if you want to speak to that or if anybody else wants to share what they thought when they went to the site visit. Would be helpful for me because I wasn't able to make it.
Sure, Bruce. So I would say that I would call it a camp style property. So Bill's currently showing, a couple of pictures of the driveway. In the immediate area around the house, I would call the ground basically bare ground. I certainly wouldn't call it any of the enumerated terms. I wouldn't call it lawn, I wouldn't call it garden, and I wouldn't call it landscaped. It's well trodden and cleared of undergrowth. So the pictures that Bill is showing are pretty representative. That's how it looks. It looks, like you would see, the leaf. If you remove the leaves from the forest floor, that's what you would see, right? I don't know if that answers your question, Bruce,
Yeah, I guess it does. No, that's very good. I guess the question is, when it comes to the bylaw exceptions, does this qualify as being, because it talks about the different things of the lawns and the gardens and all of that. I guess the question would be, would this qualify for that exemption being, kind of trodden dirt? You know what I mean?
I
Once
do, and
again, if I may,
it's-
through the chair, I want to be clear that we're not asking for the 2007 exemption. I'm going to say that a couple of times. But I think that what we're trying to state is that within the vernal pool resource area, which includes the 100 feet from the vernal pool, this is what it looks like. Okay. And within those areas, we're saying that those areas are exempt. They're exempt from vernal pool definition, if you will. And I have to get the language in front of me to actually say what we're trying, what exemptions we have. But clearly, this is not pristine land that's adjacent to the vernal pool that would be considered virgin ground, if you will. It's not even close. So that's what we're saying, is that within the vernal pool definition, there are exemptions that we're trying to work with within the overall scope of the plan. And those areas are highlighted in here. That's the shaded area. And in 2020 hindsight, maybe we should have submitted a plan that showed a shaded area during the review. We went back and forth on several different items along the way between the vernal pool. There was time, and then there was the isolated land subject to flooding. Then there was the boundaries of which was a bordering and which was an isolated, et cetera. So, there was a lot of stuff that was going on. But part of the intention of placing the limit of disturbance lines on the plans when they were approved was to basically say, here's where it's disturbed on the property, or here's where it's not pristine land or virgin land. That was the intent.
Thank you, Bill. Attorney Nyland, you had your hand up. Go ahead.
Yeah, I just wanted to turn it down because I think that Bill's answered to a degree. The reason I focused on the ORAD is I believe the commission in its entirety made a decision as to where that area was disturbed when you issued the ORAD in 2023. The line was shown on the plan as to where the disturbed areas were, and that is what you adopted when you adopted the vernal pool definition as a resource area. As Bill says, and it reads in the definition, the boundary of the resource area for vernal pools shall be 100 feet outward from the mean annual high water line, defining the depression, but shall not include existing lawns, gardens, landscaped, or developed areas. We presented that as a developed area on the plan, and after a peer review and after review, that was approved by the commission. So I don't believe that's open for debate at this stage. There are cases that deal with overturning or having a second opinion as to an ORAD or any other ANRAD or otherwise, say that there has to be fraud or a mutual mistake. This ORAD is good for 3 years, and this is the area that we're going to be working with, and that's the delineation we're going to be working with, regardless of what the commission may think in 2024.
Thank you.
Thank you. Dennis, you have your hand up. Go ahead.
Yeah, I wasn't on that meeting where we approved the ORAD, but I did go back and listen to it, and Chair, you were pretty explicit that we were not getting into a litigation there or discussion there, or a decision on the disturbed area, and where that boundary was. That that vote was on the vernal pool itself, and the wetlands. So, I've got some concerns. around that disturbed area. I think some things like the driveway have definitely been there the whole time, the immediate area around the house. Some of the other areas underneath the trees, not lawn, but to say you could have a wetland, you could then do ground clearing and then have it surveyed. And then I'm not saying that's what happened here, but the question becomes, when was that disturbed, right? Was that disturbed prior to 2008? Was that disturbed post 2008, right? So I'm not saying these owners, they bought the house afterwards. The conditions may not, I don't think we've seen anything as to the timing on that yet. And I think that's what's important on whether or not it becomes exempt or not. And right now, I've got concerns with it.
Right. Thanks, Dennis. I just want to comment on what you said. I don't want the commission to deal in hypotheticals. I think we really need to deal with facts and things that we know. So we certainly have had testimony from the public to some degree saying this or that happened in the past. But I don't think that a lot of that we can know dates for certain or other important information for that testimony to make it relevant. So I think we need to be careful when we're looking at this project, that we limit what we look at to things that we know and that we sure that we know, things that we've seen with our own eyes, things that are facts. So I don't want to entertain, so I think someone in testimony in the past in a letter to the commission suggested that this was clear cut a few years, all of the understory was there a few years ago and was removed. Well, the problem with that kind of assertion is it's not falsifiable. So I don't think the commission can rest any decision on that information. And I don't, it's interesting information, but I don't think that we can use that as part of our fact finding or decision making. Having said that, though, I think the question of this exemption, we need to have that discussion. I see a whole bunch of hands raised, and I have a whole bunch of points that I would like to make also, but I think I'd like to hear everybody else's points. I don't know who between Jim LaValle and Attorney Nyland had their hand up next, but I'll go with Jim first. Go ahead, Jim.
Yeah, thank you. So I'll be brief. So first of all, thank you, Dennis, for reporting on the previous meeting video that you went back and watched, and that is exactly my recollection. To me, the limit of disturbed area is still an open question, and that is not what we approved when we approved the ORAD. That's pretty clear in my mind.
So I will say this, I also listened to the meeting, and I have a slightly different take on what I said. I certainly said that there is an exemption in the bylaw, and I was thinking about 215.5, not the vernal pool boundary exemption, but the blanket exemption to the entire bylaw. And while I did say, I said quite forcefully that that the commission could be bound by that red dash line. I don't think that red dash line has changed at all from the ORAD that we approved. But I also said that that I think the discussion about the meaning of that line, that the ORAD wasn't the appropriate forum, and that the meaning of that exemption would have to wait for the actual notice of intent. Now, I'm not sure that was necessarily the right thing to say, those two things. Since we've received comment from both the proponents council and the abutters council, We've also received an opinion from town council. My thinking has certainly evolved in how to view this project and in specifically how to view the bylaw. So I do see Attorney Nyland, you've got your hand still up, so please go ahead.
Yeah, and thank you. I wasn't aware that town council had weighed in, so I'm hoping that you'll share that with us if you're able to. I listened to that same discussion that evening and came away with an understanding that when you were talking about not making a decision on the blanket disturbance, that it was that as it related to going back to 2007 with respect to the exemption from the bylaw, which is different than the exemption from the vernal pool. Bill has said 3 times, we're not asking for any exemption under the bylaw, to be exempt on the bylaw. The vernal pool decision is not as disturbed as of 2007. It shall not include existing lawns, gardens, landscaped or developed areas. There's no reference there to 2007. It was written by the same people. You know, the 215.5 is an entirely different set of standards because that goes back to 2007, and everybody in that discussion that evening agreed that they couldn't make a decision as to the application of the previously developed as of 2007 at that time. That was very clear because there weren't facts introduced as to what had taken place in 2007. However, it was clear from the plan as to the vernal pool what the disturbed area was. It was clear on the land and it's clear on the plan. So our view is that that decision was made. The last thing I'll say is you were very clear in the ORAD to make a distinction or a decision acknowledging that the one portion of the property was not applicable to the ORAD. You made it very clear. If the commission thought that there was a distinction to be made and that you weren't acting on the disturbed area and the vernal pool was not where Bill Hannigan said it was, then you would have done that in the ORAD. And that didn't happen. You adopted the ORAD according to the plan, and that's where I believe we are.
Yep, I understand your position. So, yeah, I think, yeah. I don't know that it matters so much what was said in that meeting. I think, well, okay, so it does matter what was said in that meeting for sure. But the ORAD was approved, and I think Attorney Nyland's absolutely correct that we're bound to what's on the plan for the ORAD. So my question to the commission is really a simple one. It's what's the meaning of developed areas, right? That's really the crux of this entire discussion. The language of both the 215.5 and the 215.3 exemptions that the applicant is, well, the applicant's not asking for the 215.5, and that's what I was speaking to at the other meeting, but it doesn't matter because the language is the same. It shall not include lawns, gardens, landscaped, or developed areas. And so the question to the commission is, what is a developed area? If the commission finds that this bare ground is a developed area, then I think the applicant's assertion is correct, that the shaded area on that plan is not subject to regulation by this commission, or at least not subject to regulation as a vernal pool. A portion of that is within the buffer zone to wetland A, so there would be a different discussion there. If the commission finds that bare ground is not a developed area, then we have a completely different discussion. So I think as a commission, we need to decide what that means. In my personal opinion, that bare ground is not a lawn, it's not a garden, and it's not landscaped. That, I'm very comfortable with stating. I spent a lot of time over the last few months thinking about the meaning of these exemptions, and what that means, for projects such as this. Since we've received this plan, I've been thinking about this. So what does developed area mean? And I'm sure that all four of us are going to come up with a different answer. And you need to decide for yourself. But this is my thought process. I want to compare and contrast with some other things. So if you think of the standard American dream house, like postage stamp, right? That's developed. You've got a lawn, you've got your white picket fence. I don't think that anybody with a straight face, I couldn't with a straight face say that entire, quarter-acre lot isn't developed. Clearly it's been completely changed from the natural environment. On the other side, you've got the forest that, in various places in town, we've got plenty of forest. We've got the town forest. Was that ever developed? I don't think so. But it certainly was cleared. 200 years ago, there wasn't a single tree in pretty much anywhere. I mean, obviously we had whatever, that 400-year-old tree. But for the most part, Massachusetts was almost entirely clear-cut for farming. There's very few stands of old growth forest that goes back to before colonial days. So at some point in time, almost every square foot of this property was cleared. Almost every square foot of every property was cleared. Is that considered development? I don't think so. Then you consider agriculture. There's oftentimes nothing on the ground in agricultural fields, but yet this commission has never held that an agricultural field, when converted to a residential use, was previously developed. A fallow agricultural field is not considered developed. So where's the line? What about the quarry? So in North Lancaster, we have 400-acre parcel that's been used as a quarry. That has a lot of bare ground. Is that developed? I don't know the answer to that question because that hasn't come before us. So I think that's really the question that we need to be asking ourselves. Is this bare ground developed? Let me compare and contrast to the other enumerated terms. So a lawn, okay? How do you get a lawn? You actually have to do work to produce a lawn, right? You need to change the soil, you need to plant the grass, then you need to maintain it. If you don't maintain it, it doesn't stay lawn very long. It's not a thing. You have to construct a lawn. Lawn just doesn't appear. Same with a garden. You have to construct a garden. You have to work to maintain the garden. Landscaping. So a landscaped area, what does landscaped mean? When I think of landscaping, I have landscaping at my property, right? I have a flower bed in front of my house. I've got a walkway. I've got a flower bed that's adjacent to the grass. We've established a border between the grass and the landscaping. Is this property landscaped? I think in some areas this property is landscaped. When I was there on the site visit, there was clearly a rhododendron there. That I presume that was actually planted by somebody. I think there was probably an attempt by someone to do some landscaping there. But is the entire property landscaped? Just because it's bare, just because we've been clearing the understory? Someone in the past has been clearing the understory. I don't know that counts as landscaping. In my previous home, I had a half wooded lot, and I would occasionally clear out the understory adjacent to the lawn because I just liked the way that looked. Was I developing those woods? Is that a developed area? Or is that just I'm modifying the natural environment a little? So I think, commissioners, you need to think about some of these questions and come to your own conclusion. What I'd like to do is I'd like to have a little straw poll of the commission to see, to provide some clarity for the applicant, whether we think that these areas are developed and qualify for either of the exemptions or not. Because if there's not enough commissioners who think that this qualifies for the exemption, then obviously this plan has some issues. If enough commissioners think that it does qualify, then we should move on to reviewing the plan as is. But I don't think we touch the plan until we have an understanding on how we view the exemption. Bruce, I see your hand up. Go ahead.
Yeah, thank you, Tom. That was very helpful. I guess what I'm trying to think about is, and I'll give you my opinion on what I think is developed in a second. If we adopted the ORAD, then does that, for this particular project, does that take our opinion on whether it's developed or not completely out for this particular project? Because with me, from the pictures that I saw, and I didn't go on the site walk, so I didn't see it live, but I don't think that's developed enough in order to make that exception. But if we adopted the ORAD, then does that remove that discussion from our hands for this particular project? Like, for example, if the next project comes up and then we don't adopt it because we don't think it's developed. So I guess that's kind of my question, is I don't think it's developed enough for the exception, but because we adopted the ORAD, does that remove that from this discussion for this particular project? I guess is my question.
So that's also an important question. So the applicant's attorney has made the case that by adopting the ORAD, we have bound ourselves to that interpretation. I'm not a lawyer. I think that the Abutters Council has made an opposite case. Town council has told us that it's basically up to us to interpret our own bylaw, provided that we do it deliberately and not capriciously, and that we appropriately find fact to support whatever our decision is. The court system would likely uphold our decision. I don't want to guarantee that this process goes to court. Obviously, nobody wants that outcome. But I do think we need to understand the meaning of this exemption. And frankly, now having read it and sort of faced it on the field of battle, if you will, I kind of wish it wasn't so general. The other thing I would add is that, so to this point, I've only been thinking about the exemption in terms of 215.5, the blanket exemption. And I actually think it's kind of curious that the applicant isn't asking for that exemption and is narrowing their request to just the vernal pool. And I find that's curious because it's essentially the same language, except that it doesn't include the condition of a customary appurtenance. But leaving that aside, my curiosity aside, what does developed area mean to me? To me, it means I've done something. I've done some work to produce something that isn't natural. I've put in a lawn, a garden, or a landscaped area, or also I've built a path, I've built a driveway, I've built a shed, I put in a pool. in the context of 215.5, the blanket exemption, those are all customary appurtenances to, a single family home or a business, right? You put in walkways, you put in driveways, you put in parking lots. The vernal pool doesn't have the customary appurtenance condition. So it certainly is more general. Doesn't require an existing structure, right? But there is a structure on this property, so that's kind of a moot point. I don't know. I'm rambling now, Bruce, so I'm going to stop. I don't know if I answered your question.
Thank you. And just as far as it goes to developed areas, for the straw poll, I agree with you that I don't consider that a developed area.
So if there are any more comments or questions from the commission? I don't know. Yeah, go ahead, Jim.
I'll just go. So I think you could say some areas are previously developed, the driveways. You could actually see some movement. But I do think much of the site is just the understory being cleared. And so for much of the site, for me, that is not previously developed.
Okay, thanks, Jim.
I'm in kind of a similar boat. I think it developed is, you're putting a lawn in, you're grading, when you're landscaping, you're grading, you're bringing soils in. It may be disturbed, but I do not feel that a large portion of that is developed. I agree. There are sections within there that would meet that developed standard, but I think it's a smaller footprint than an overall shaded area.
Okay, thanks, Dennis. So I agree with the other commissioners that I do think that there are areas that are clearly developed. Obviously, the structure, I mentioned the rhododendron that I saw, clearly the driveway. The entirety of that shaded area, as I indicated back in August, I said the equivalent of if we saw a plan that asked to cut all those trees down, I wouldn't look very favorably on it. And that's what I see in this plan, that essentially all of the bare ground is being converted to a development. And I don't see that as, frankly, I don't see it as qualifying for the exemption because I don't feel that most of that is developed. I've gone back and forth on this, to be perfectly honest. Before any of councils weighed in, I was pretty adamant that we would follow that line and restrict this entire project to the WPA. But having seen council opinion, I don't feel that way anymore. Yeah, Mr. Hannigan, you've got your hand up. Go ahead.
Yeah, I understand, and you've obviously put a lot of thought and time into this matter. But if we're going to look at the word developed area, I think that you also need to go back to your definition and take a look at the definition of alter, because in the definition of alter, which is if you develop, you're altering, and if you're altering, you're developing. So removal, excavation, dredging of soil, sand. So that would be to go back to the gravel pit or the quarry. Whenever we've brought a project into any town where there was a previous quarry, that's always been considered previously developed whenever we file a site plan or a notice of intent or whatever it may be. So that's a factor that's out there. I believe that it may be that the previous owner or even the current owner has maintained it, is maybe they just like that there's nothing on the ground, that they like the stone, that we showed earlier, you know, there's the around the tree. They drive around that tree. This is the stone that's on the ground as they walk over to the lake. It's a camp lot. That's how they maintained it. So landscaping, I mean, we're working on projects right now where we're doing landscape plans that don't have plants, that they're hardscape landscape. Now that's different, you know, than what we're seeing on the screen, but there are elements such as footpaths, like you mentioned, that have areas that there's no vegetation proposed or planned. It's still developed. I don't look at this picture and say that that's not developed land. And I don't look at this as being not developed. I mean, there's areas, maybe this area is not developed, you know, I mean, but that's why we went out and marked it on the ground and then surveyed it so that we could then recreate it. So, I mean, if it means us going out and staking that red line that's on the plan so the commission go out and look at it, that maybe that's the next step, or maybe that's one of the next steps. But I don't believe that the commission would look at this as being not developed. This, to me, that's developed around the house. That's just how they maintained their area around their lot. That's a driveway. I mean, to me, you know, in the bulk of it, in the bulk of the down here. So where we're looking right now on that previous picture was right about in this area here. So maybe by going out there, I mean, we tried to do it so that when we marked it on the ground and surveyed it the same day, basically, that we were out there with Chuck Karen and went through everything and looked at everything. I mean, maybe there's an area over here that isn't really developed. You know, you can see there's some tree lines there. There's some trees that are in there. You know, this is the center tree where everyone drives around. So that's really what we call that area as being. There's a cart path that goes off into this area, which has a chain across. So I mean, we didn't just haphazardly go out and mark these areas on the ground to avoid the regulation. In contrast, we actually marked it on the ground and showed it on the plan specifically so that when we came back with the notice of intent, that a demarcation line was placed on the plan that the commission saw, that the commission then approved to say, this is the resource area. These are the areas on the plan or on the project that have some form of previous disturbance or development or grass or landscape that would provide some sort of exemption or relief to the applicant. And if you remember correctly, when we went through the first part of the NRAD, Don Chasen was on the board at the time, and he's the one that actually brought it to our attention that within the definition, those areas are exempt. And his conversation was more or less, and I don't remember the exact words that he utilized, but you need to go out and locate those areas and show them on the plan. And that's what we did. So I'm at a loss for why the members. I understand this is not right now. I think we're still in the discussion matter of what are we going to call this? But when we went through the process in 2023, we went through it very deliberately to make sure, because it's a very tight lot, okay, relative to the area that they want to build around these two wetland areas. We talked about whether one was really a wetland or whether it was a lined wetland area or lined area that the guy used for a skating rink. That was eventually where we basically pulled back from that once we saw the groundwater conditions and the elevations relative to the pond. It all kind of said, you know, this is a wetland. It doesn't matter that there's some plastic lying in there that the guy, either the last owner or the previous owner prior to him, put in there to make a skating pond. These are things that we went through very, very deliberately to present to the commission as much information as possible to be able to allow them to make a decision about what they're approving relative to the ANRAD. We had peer review by Brian Butler of Oxbow. We did isolated land subject to flooding calculations. We did vernal pool review. We went back in the spring and did that. We then, per Commissioner Don Chasen at the time, we went out and located all the areas that were the limit of where there was stuff out there that was disturbed and or utilized and or occupied and or driven around a tree, etc. We located those areas to put them on the plan. And I think that maybe there's a lesson in this, that clarity on both maybe the regulation side needs to be addressed. But I don't think that it's fair to the applicant that they aren't able to utilize these areas in the manner that the bylaw permitted them to file an ANRAD and that the commission approved. Now, once we get to that point, the extent of what we're doing with respect to, how close are we coming to the vernal pool? Can we move away from it a little more? Can we make adjustments in the site plan to make the situation better? Those are conversations we can then start having. But until we get to the point where the commission acknowledges that the approval of this plan locked in where where the landowner has the right to do work, we can't make it better because you're almost forcing us to stay within this boundary to be able to move forward. So, are there alternatives to the red line that's on the plan? Are we in our proposed plans? I didn't bring them up, but in our proposed plans, are we going right up to that red line in every case? I don't think we are. Those are the discussions that we need to be able to have. And until the commission accepts this plan as what the ORAD approved, those discussions become kind of fruitless. So we're kind of at a crossroads where I understand, Mr. Chair, taking a straw poll is a good idea, but I think you're taking a straw poll on something that's already been decided.
All right, thanks. So I understand. I understand what you're saying, Bill. Yeah, I think. How do I say this? When you say that the proposed plan doesn't go right up the line, that's not really what I see on the proposed plan. There's no way that the proposed plan maintains the values of these resource areas.
And I'd love to get into that. I'd love to get into that discussion. Okay. But I can't get into
Sure.
that discussion about what we're doing on the proposed plan till we agree that the existing plan is what we're working with.
Yep, I understand it, and I'm in agreement with you. I think that if the commission's ultimately going to deny because they don't think it's exempt, and therefore wants to apply very strict standards, then we're going to end up at an impasse for sure. And I think the sooner we reach that impasse, the better off everybody will be.
Well, and then the other part of it is that there's the potential for, okay, in other words, just because the commission's locked into this plan, in my opinion, okay, not necessarily the commission's, they're not fully there yet, but that doesn't mean we couldn't start discussing alternatives, okay, to try to improve. And maybe one of the things that we could do is maybe we pull back on anything we're doing right in this area here so that we're providing more of a buffer. Maybe as crazy as it sounds, maybe we revegetate this whole thing and we move the driveway out here. Okay. So that once we get into the point where we can agree that this is the area that we're working with, we can start proposing alternatives to make it better. But us proposing alternatives to make it better when we don't know what we're, because if the commission agrees that this is the area of previous disturbance, however we marked it on the plan, okay, we can't create new by your own bylaw, we can't create new disturbed areas within the vernal pool buffer. Okay. But the commission could apply a waiver to us to allow the driveway to be moved up in this area here, for example, because of the fact that this is too close to the vernal pool. Therefore, we'd be able to revegetate that and basically provide a better situation post-development than currently exists. We can start getting into those discussions, but I can't get into those discussions until we start having the comfort level that and maybe the commission has to I'm not sure which member said it before, but maybe you have to take the position of, hey, you know something, we approved this, it is what it is, and we maybe shouldn't have, but the applicant's willing to make some changes to their site design plan to help us out, and let's see if we can't get that accomplished. Okay, that I think makes a lot more sense than us going back and forth on whether because in my opinion it's been set, the lines are on the plan, the buffer, the jurisdictional area was established with the disturbed areas within those areas. So I mean, I think we have a pretty strong case on that side. I'd rather try to find a resolution to the real problem or the real concern, which is how do we better protect the vernal pool, in my opinion.
Okay, thanks, Bill. So I see 3 hands raised. I'm going to go to Brad Stone first. Go ahead, Brad.
Thank you, Tom. So a couple of quick things. So just because I wasn't here during the ANRAD process, so with respect to, in general, when commissions do issue an ANRAD, you should hold that line. And that's what I would typically recommend to the commission in those cases. Yes, as mentioned before, sometimes those have been overturned. I've seen it happen at the superseding order level. I've seen it happen beyond that. It's not common, but changes can be made for whatever reason. But before we got to that, I guess what I'm a little bit confused about, while we've had a lot of the discussion going on, I did start going through a little bit of the history during the past 20 minutes or so. And just for clarification on what the commission's received and what we've issued, what I see in the determination was the plan that was referenced in, let's see, so it was the revised plan with the June 27th, 2023 date. And as I'm scrolling through that and looking at the resource areas, the only real thing additional, what I typically see that's been part of the discussion tonight, is this limit of existing disturbance. And I guess what I'm trying to figure out in terms of what the commission agreed to in terms of resource area is, how does that particular language correlate to what's being interpreted in the bylaw as part of the vernal pool? Because I'm not sure that alone, in my mind, indicates that the commission somehow determined that, unless there's other things in the documents of the plan that I haven't looked at yet. So I guess I'm kind of looking for my own knowledge to hear from people that were involved with this, and maybe that would help sort through whether that determination has been set in stone at this point on that particular issue. Because it seems like, it still may be a little bit up in the air, so to speak.
So, Brad, I think yeah, so I'm not sure how to exactly answer your question, to be honest. So clearly the intention of the applicant was to identify the area that qualified for the exemption. But it doesn't actually say that on the plan, right? It says limit of existing disturbance. So we had, there was a back and forth at the meeting where the ORAD was approved about exactly what we were talking about there. And what its meaning was under the bylaw. It wasn't talked about that explicitly as we're talking about it right now. I accepted it for what it was, which was the limit of existing disturbance. That is in the area that was disturbed. However you wanted to define disturbance. I don't know how the rest of the commissioners took it. I can't speak for them. I don't know if that answers your question. I'm not stating. So when I reviewed that plan, I thought that the commission was agreeing that that area was disturbed. I did not necessarily agree that the commission was saying that that entire area was fully exempt from the bylaw. And as the applicant has clarified tonight, they're not saying it's exempt from the bylaw. But I think the other point that I would make on this whole plan is that even if we were to grant that area is exempt from the vernal pool language, it's still within the buffer zone to wetland A and also wetland C. So it's not like it's not jurisdictional. I don't know if that answers your question, Brad.
Well, no, I mean, I think the vernal pool is probably the most important part here, though. And I'm just not seeing that that's really been determined as I'm reading through the ANRAD docs. That's all. So I was hoping to get something a little bit more concrete that would convince me otherwise. Either from the commission or anyone else, but I didn't find the answer I was looking for, or I could look at the plan and say, in black and white, this is what the commission agreed to.
So if I wanted to be pedantic, I would say that the limit of existing disturbance has no meaning or definition in the bylaw, regardless of what anybody intended. That would be pedantic, Tom. I think there was a general understanding at that meeting that it did mean that this was the disturbed area, and everybody was thinking that that somehow related to the exemption. I certainly was thinking that way. So that's the non-pedantic Tom, for whatever that's worth. So commissioners, oh, sorry, wait, I can't see the hands anymore. Okay, that's right, there are several other hands. Attorney Nyland, you have your hand up, go ahead.
Yeah, thank you. You've been very generous. So I'm going to just answer a question that you posed yourself, Mr. Chairman, with respect to why I argued the ORAD and I didn't argue 215.5, and it's fairly simple. The ORAD, as we've talked about and as Bill explained, took an evolution. We submitted a plan, then when the members asked us where the disturbed area was, the developed area, then Bill put it on the plan. He testified to that this evening, and that's exactly what took place. The 215.5 exemption requires me to go back to 2007. I didn't have any personal knowledge of what was taking place back in 2007. So there was no need for me to argue that exemption when I have an ORAD that's got a line and has everything in front of me that's been approved by the commission. So it seemed to me to not only be redundant, but it was an unnecessary to go through that argument. You'd asked why I didn't use that argument when the language developed area was similar. Well, the only thing that's similar in the version is the word developed area, because one has to do with a total exemption from the bylaw and goes back to 2007, and the other relates to the definition of vernal pool. So that's just to answer your question. That's why I only needed to deal with the ORAD and the language that's on the ORAD and the plan that was approved.
Okay, thanks for that clarification. Jim LaValle, go ahead.
Yeah, thanks. So a little while back, I made a statement. I thought some areas were previously disturbed and others maybe weren't. But I want to understand, Mr. Hannigan, what you said a few moments ago that may offer some help. And you referred us back to the definition of alteration in the bylaw. So were you saying that if something occurred that meets the definition of alteration, then you consider it disturbed, previously disturbed?
I absolutely would. Yeah. If you alter something, you're disturbing something.
Okay.
I think importantly, it's H is destruction of plant life, including cutting, trimming of trees and shrubs. Well, would they maintain the area that they maintain at some point along the way? That had to be done. And I think one of the important things about the ANRAD over the bylaw, and I think Attorney Nyland touched on this a little bit, is that the vernal pool definition is as of the date of the plan that we submitted and was approved. Okay, it doesn't look back to what happened 6 months, 6 years, or 6 decades ago. Okay, it's that plan that's in front of the commission right now that they're approving. They're approving the wetland delineation at that time, and they're approving the location of the vernal pool bank, and therefore they're also approving the resource area. And specifically, when early on in that process, when we started talking about is it a vernal pool or not, part of the idea was, well, what if you called it a vernal pool, even though you don't know if it's a vernal pool until the spring, then at least we'll know what we're dealing with. And at that point, we said, no, we'll just wait till the spring and do that. And that's when the whole discussion came up relative to the disturbed areas. And my apologies for summarizing all of this information in a note on the plan by just saying disturbed areas. So that, I think that's really how we got to that line on the plan. And if you go back to, so I don't think that developed areas, okay, is any different than disturbed areas, landscaped areas, areas that are void of vegetation and removal of excavation of dredging of soil, sand, gravel, aggregate materials of any kind, which would be presumed to be a quarry or a sand and gravel operation. Drainage disturbance of water level or water table, we didn't do that. Dumping and discharging materials which may degrade water thing. Activities, changes in work which cause or tend to contribute to pollution. Okay, so some of these things we're definitely not doing, but taking the plants out, altering, I'll step back on that now, because now I'm reading the top part of it. This altering definition, similar to what you have some definitions that mean something to something and they don't apply. This is actually specific to within the resource area. So now we're talking about the resource area, and when you define the vernal pool as a resource area, any of these things that existed at the time of the filing or at the time the plan was approved, okay, would be considered within the resource area of the vernal pool. So that I'm just trying to, I know that the chair was trying to go through each of the individual things and say, what do you see? What do you see? What do you see? And I commend him on that. I think that that's a very good approach. But I think that just because it's not stated as disturbed or developed doesn't mean that it's a parking lot. It means that someone could drive over it. Well, that driveway is developed. I don't think there's any real argument about that. The area up by the house, that's just a different form of landscaping. Some people plant grass, some people don't. And maybe because of the fact that it was under the canopy, it never really had a lot of growth in that area, and maybe they just liked the way it was maintained. I can't speak to that. But as of the date that we submitted the final plans and they were approved, those are the conditions that were on the site. And that's what the commission approved, if that helps.
Yeah, I think for me, you may be able to help me get there by explaining why it's a previously developed area in the context of the definition of alteration. I will say, though, I do have trouble with calling trimming of trees and shrubs an alteration. We allow vista pruning all the time.
Right.
You consider it an alteration.
Right. So, but part of that's up to the commission. I mean, I think that when we brought the ANRAD to the commission, we were asking for guidance. Tell us where you think, or tell us if you agree that what we're showing on the plan as a resource area, and there are 3 different types on this particular one, maybe even 4. Okay. Tell us that you agree with us. And then we'll go from there and we'll go do our design work. The extent of work we do on the site with respect to the areas that have been delineated, that's a completely different discussion relative to, if we paved this entire area, okay, just because it was previously disturbed, that I think is what the commission would find objectionable. Okay. We've developed it with a large house, a driveway, and a second garage. Okay. Once again, being able to get past this point that we're at and start discussing changes to the plan that the commission would be comfortable with, that would also improve the conditions at the resource area, is where I'm trying to get to, but I can't get there at this point in time.
All set, Jim?
All set.
Okay. I still see 2 more hands. I want to stay focused on the commission and the applicant right now, so I'll get to Patrick Gardner and Attorney Roloffs in a bit. Just want to see if there's any more commissioners or Brad, any more questions or comments? Yeah, go ahead, Brad.
So just another quick thing. So when I looked at all of the documents that were coming in recent weeks, including both attorneys' letters, things of that nature, I just want to not lose track of where the definitions are actually coming from in the bylaw. So when we're talking about alteration and looking at how alter is defined in the bylaw, and it sounds like we're hearing from the applicant applying that to the vernal pool. I did a word search when I opened up the bylaw. I looked for the word alter, and it showed up in 3 spots. At the very beginning, for all of the different resource areas that it listed in the bylaw. And it's quite typical, because one of the big questions that a lot of people have from, a property owner side, a commission side, a consultant side, is what really constitutes alter in a wetland. So when you have the 8 interests of the act, there's a little bit of silt, or do you need a few inches of silt in a resource area, or what type of pollutant in this particular water body is actually altering? So when you look at alteration there, that's, in my mind, when I've read and reread it again, that's what that's trying to define, is what are your typical resource area impacts, what constitutes alteration. When I go back to the vernal pool definition, I don't see, and I'm looking at it again one last time, I don't see alter in that. The only thing that I see that would throw out components of that definition are shall not include existing lawns, gardens, landscaped, or developed areas. And I don't think you can look at lawn, garden, landscaped, developed area and try to interpret what those are based on what the earlier part of the bylaw is trying to do and define what constitutes a resource area alteration. I think for the vernal pool, it was very specific. It looks like they were trying to, as mentioned at the very beginning of the hearing, you try to exempt certain existing features, and these are definitely what would be existing features that may not have particular, value to vernal pool habitat. I'm just not sure that, the definition of alteration necessarily applies to this vernal pool part. And, getting back to my earlier concern about the ANRAD, I'm still not convinced that, what the commission issued in the ORAD in terms of disturbed area really solidified this vernal pool boundary too. So I guess that's my latest update, so to speak.
Mr. Chair, if I may just, um,
Sure.
my discussion regarding the alter was basically to talk about the developed area where the chair was discussing, what's considered a developed area. Well, developed area would be something that would be more altered. So that's the reason why I jumped back to that definition. And I don't disagree with you. The two probably don't correlate. But that was where I was heading with that.
Thanks, Brad. Thanks, Bill. Go ahead, Dennis.
Oh, now I lost my train of thought. We were also talking, I'm just trying to see a way forward here. We were talking about, some of this, the exemption is for the vernal pool, but some of it would also be covered probably by the bylaw based, I think I've heard our conversation correctly. The bylaw to like the wetlands, right? So I'll be honest, the area I'm most concerned with is the area, if you're looking at the plan, it's to the right of the map. That's the area where I don't think it meets the developed standard, where we've altered the soil or in that area. I'm not saying it correctly. We haven't done grading. We haven't done hard landscaping. I think immediately around the house, you've got the driveway. Those are pre-existing, developed 100%. It's kind of in the area to the right of the existing driveway. It's also within, I think, 100 feet of wetland A. So does that mean that would still be jurisdictional to us through its proximity to wetland A, regardless of this vernal pool decision?
Yes, it would still be buffer zone to wetland A.
Okay.
Also wetland C, which is surrounding the vernal pool.
Just surrounding a vernal pool. Okay.
If I may, through the chair,
Sure.
as we were out there the day when we saw the driveway was overburdened with the water, we discussed just after that about the fact that this would need to be relocated basically into the area where the driveway was, because this would be new disturbance. And this is an area that, so we haven't made any changes to the plans because we're still trying to sort out what we're going to change. So we agree that this force main and cutting through this area here, I think, Dennis, that's what you're talking about, that would have to be relocated, and we wouldn't be able to do that. That's
Actually,
not
I was talking to your shaded plan on the existing condition. So no, I
Okay.
am even farther up, the area north of that wetland A to the right of the existing driveway area. Down in that area and even southern, you've got a lot of large trees there. That's the area where the underbrush has been cleaned out underneath. So disturbed, yes. Developed, in my opinion, no. And that's the area that I'm concerned with in the exemption.
So that area is the area that is around the tree where they drive around. That's this area right here on the plan. So this is where, if you went to the site walks, this is where everyone parked, because you come up here and you drive around the tree to get back out. So that's why that area was demarcated on the plans.
Yeah.
See.
And then
Seems to
Bill,
be
there's also
deeper
a wooden
farther
foundation.
back.
As you move down to the water, there's a wooden foundation that's in the ground there, that was there previously. And then as you go further down, there's a septic.
So there's the wooden foundation, which is next to the boat, which is over here. Okay. This is the old sauna, which is
Yeah, that's up by the water.
right. The sauna is actually over here.
Yep.
In this area, right here.
And then the current septic is right to the right of the house there that that area you were mentioning.
So this is where the septic system is. Jeremy, just to identify yourself for the record.
Sorry, guys. This is Jeremy Quill.
So the septic system is in this area here. This is where the old sauna was. So this is the area where you see all the stone in this picture. That's the house is to my right over here. And it's looking out towards the water from that area there.
Right. And then if you go to the plan where you're driving around is farther north on that map, right? That tree right there is the 15. Right. I'm talking the area south of that.
So you're saying this area here?
That area in there.
Okay. So these are the things that if we start to, adopt this as being real, we can start making adjustments to the plans to address concerns the commission has relative to what we're doing, where we're doing it on the site, which is typical. But we're trying to get to that point, and we can't get there until we're comfortable with this.
Yep, we understand. So Dennis, you're all set?
Yeah, I'm good.
Okay. So we've been going back and forth on this for a while, so I'm going to go to the public. I'd like to maybe not keep running for the next hour on this. So let's see, I see Attorney Roloffs, and I probably pronounced your name wrong, sorry. And Patrick Gardner, have your hands up. Attorney Roloffs first, go ahead.
Thank you, Mr. Chairman. I know Mr. Bowen and Mr. Garner both want to speak as well quickly, and we are going to be respectful of your time. Can I quickly share my screen?
Sure.
Okay, I'm not going to hit all these slides. It's not even that many, but given the discussion that's been had, I'm going to be able to skip through some of these pretty quickly. Let me start actually before I get to the exclusions and exemptions. I don't think the commission should at all be troubled by the fact that the ORAD plan that was approved included a limit of disturbance line. I also went back to the August hearing. I know that Mr. Bowen was very concerned about the commission or somebody down the road potentially viewing that line as defining an exclusion or an exemption. And so he specifically brought that topic up. And Mr. Chairman, I understand I heard what you said tonight. You might have meant something else, but I assure you that Mr. Bowen and myself in reviewing it felt pretty confident that there was no intention when it approved a plan that happened to have a limit of disturbance line, that line was somehow defining the scope of an exclusion to the vernal pool resource area. And just as another example, Mr. Bowen actually mentioned that the plan also referenced the 100-foot vernal pool buffer zone as a buffer zone, not as a resource area. And I think the response was, we know what our resource areas are. The understanding was basically you were defining the pool, and then you could measure out from that as to what the resource area actually was from the edges of the pool, which were defined on the plan. So we're not looking to reopen the discussion of the pool boundaries or the wetland flag locations, but we don't think the commission intentionally or even accidentally approved the scope of any exclusions to the vernal pool resource area. The qualitative aspects of those areas, as Mr. Chairman, you said during that August meeting, were topics to be taken up during the notice of intent process. So just quickly, here is the language. Again, we got two provisions. The language is very clear as to what's excluded from the definition of vernal pool. Shall not include existing lawns, gardens, landscaped, or developed areas. If the commission had wanted to identify those excluded areas during the ORAD process, maybe it had the authority to do that, but it would have to do that very clearly, because the ORAD process is about defining resource areas, not exemptions or degraded areas or extent of value within a resource area, et cetera. I think any ORAD intending to define an exclusion has to be crystal clear on that, and this one definitely wasn't. Neither the plan nor the ORAD itself. The language that's included here isn't on the plan. The reference to this bylaw exclusion is not on the plan. I mean, there's nobody who comes into this from the outside would interpret the plan or the ORAD as defining that exclusion. And I think that's reflected in Brad's reaction to it here this evening. So I don't think the commission should be troubled by the fact that it issued an ORAD approving a plan that happened to have a limit of disturbance line on it. A limit of disturbance is significantly different than the limits of lawn, gardens, landscaped, or developed areas for all the reasons we've talked about, and I've discussed at length in my letter. Doesn't mean that you can't define those here. So now we're in the notice of intent process. If there are portions of that limit of that area of disturbance that you think qualify, that's a determination I think the commission can make here, and it should be looking at the evidence before it. One of the points that came up this evening that the applicant's counsel and consultant have made is that the exclusion in the definition of vernal pool should be based on the current condition and not based on the condition as it existed when the bylaw was adopted. I totally disagree with that. I think when this says that you exclude existing lawns, gardens, landscaped, or developed areas, a property owner doesn't get credit for changes that they've made just before filing their ANRAD or their notice of intent. I think the intent here, when they referenced existing, was to go back to the point in time existing as of when the bylaw was adopted. Maybe you would get credit. Of course, you would get credit if you had done work pursuant to an order of conditions or the authority from the commission. But I don't think going into a wooded area and mowing it or raking it and cleaning out the understory and leaves and sort of the other normal forest litter that was likely out there before those activities happened should be disregarded. Going on to the provisions, I'm not going to go into these. These are all in the letter that I submitted. I will point out, though, that within the bylaw itself, the commission is instructed to interpret the bylaw in a manner that's consistent with its purposes, and it's very clear that the bylaw was intended to be more stringent than the state program in protecting additional resource areas, additional values, additional standards, et cetera. Changing and altering are different concepts. Neither of those constitute development. I'm going to quickly stop here. This is a plan. So Mr. Bowen did submit a letter dated March 15th with photographs, a plan, and a discussion of the conditions as he observed at the relevant time period, back in 2007 when the bylaw was adopted. The best evidence that you have of those conditions is Mr. Bowen's testimony, because he was out there. He personally saw it. Mr. Chairman, I get your point that you shouldn't just accept it wholeheartedly, but it's relevant evidence. And so is the condition that you might see out there now. That might be relevant to how it looked, years earlier, but you got to weigh the evidence that's in front of you. You should not disregard Mr. Bowen's evidence as described in detail in his March 15th letter, which I urge you to go back and read and review. But this was one plan that was included with his letter, just pointing out that some of this blue area of what they call a driveway is not actually a driveway. It may be used now for vehicles coming and going and coming through here and turning around. But I think you can see that the existing driveway that was really the established driveway was in a much narrower location. And then these areas that are highlighted in green on this sketch that he did are filled with trees and had quite a bit of understory, typically historically at this property. I won't go through these in detail, but just quickly, these are all attached to Mr. Bowen's letter, March 15th. This is a photograph that I think was actually taken from the listing for the property. Probably the best representation of all the understory that was around the house in the relevant time period of 2007. Here are some other photos showing similar sort of natural vegetation in these areas that we've been talking about. The driveway, it actually includes vegetation right down the middle. It's not paved. It's partially gravel. And maybe portions of this qualify, but that's still to be determined. It's not something that was determined and evaluated in any detail during the ORAD process. This is a photograph of where the proposed garage is to be located at bottom right. And it actually, you were just talking about this area, questioning whether it was actually a developed area. And I think this photograph makes it pretty clear that it's not, in our view. These are areas, this is the same area, actually identifying the trees that would have to be removed for the proposed. This is the detached garage, the second garage. This photograph 7 is the area between the house and the vernal pool. This photograph from 2021 shows the more natural condition that was historically in place out there. Photograph 8 shows it in a more current condition with all the leaf litter and scrubby understory removed and raked out of it. Paragraph 9 shows the area of the septic field. So it would be in this area between the driveways, would involve a lot of tree removal. Again, we don't think there's any evidence demonstrating that those are developed areas. And you've talked about that at length tonight. I just wanted to quickly get to a figure that I did just to color up these. I just want to stress the importance of what you're being asked to determine here. I heard Mr. Hannigan assure us that they don't plan to take advantage of the bylaw exemption under 215.5. That actually comes as a surprise to me, where they're arguing that the whole shaded area on the plan that they had referenced should be excluded from the vernal pool resource. As you said, Mr. Chairman, the language is very similar. The analyses are a little bit different because the bylaw exemption also includes an analysis of the types of activities proposed. But in terms of the area, if you were to confirm that an area is indeed qualifies to be excluded from the vernal pool resource area, there's no doubt that after further thought, the applicants are going to attempt to leverage off of that finding, I would expect anyways, to attempt to take advantage of the broader exemption that would potentially pull them out of being regulated under the bylaw at all. You can see here in the green are the wetland boundaries. The vernal pool boundaries are identified in there as well. The yellow are the 25-foot no disturb zones associated with the wetlands as they were confirmed. You can see that they're actually proposing a structure, which is the orange here. within the no alteration zone to the wetland. So that's not even that local violation wouldn't even rely upon the vernal pool, the fact that this is also vernal pool resource, but we believe it is as well. But you can see existing houses in blue, proposed in orange. I know we're not getting into the details of the project, and those are subject to change, but this is just to highlight the importance of this initial threshold finding as to what areas you believe should be excluded from the vernal pool resource area, and potentially then subject to the future argument that the work proposed in those same areas should be precluded from the bylaw completely. So with that, in the interest of time, I will stop sharing my screen and turn it over to I think Pat Garner's going to speak, and then Mr. Bowen, if that's okay.
Sure, Mr. Garner, go ahead.
Okay, with your permission, thank you. I'm Patrick Garner. For those on the commission who don't know, I'm a senior wetland scientist, and I do most of my work around the Commonwealth doing peer reviews. I have submitted and reviewed dozens of NRADs and participated with commissions in issuing ORADs. I also sat on the DEP Technical Advisory Committee that put together the protocols and the processes for submitting NRADs. So I have a lot of background in both what the intent of these has been and how they've been used throughout the Commonwealth. And I want to underline initially that the purpose of the ANRAD is resource area determination. That's its sole purpose. It has no other purpose. These are not used to affirm or confirm developed areas. They're not used to affirm property lines or the location of structures or the location of driveways. They are only to determine the extent and the edges of bordering vegetated wetlands, IVW, vernal pools, and other resources as they're defined in either the Wetland Protection Act or a bylaw. So the lengthy discussion that we've had tonight that's gone on for well over an hour, just talking about the ORAD and the mapping and its purpose, I think went off the rails the moment the applicant began to try to use that plan to define the extent of disturbance. It's not what the plan was intended to do. I don't believe, I'm not an attorney, but I don't believe that legally that would stand determination in a court process. That's not its purpose. It's not found anywhere in the Commonwealth, and I don't believe I've ever seen in my decades of doing this work an ORAD that was used for a following notice of intent as it's being used in this particular case. Alter, we've had Mr. Hannigan talk about alter and the definition of alter in this case, and that being a determination that certain areas on the property were developed. And I want to note that both in the bylaw and in the Wetland Protection Act, and I'm sort of affirming Brad's conclusion here, but alter is a negative term. Alter is used to define when bad things happen to resource areas. It's not used to determine that an area has been developed because it's been altered. I mean, that's almost a bizarre sort of direction. And I think Mr. Hannigan backed away from that at a certain point, but that just is not the way alter is ever used in this field, period. Rhododendrons. Rhododendrons are an indigenous plant that are found throughout Massachusetts in pristine, undeveloped woods. Typically, cultivars, which are planted for landscaping purposes, are far smaller than the rhodies that we find on this property. I've looked at them, and my reaction when I was on the near the site was that these were natural shrubs. But beyond all of that, Well, I want to also mention that I submitted a letter to the commission dated March 19th. I'm not going to critique the notice of intent plan itself. I know we're trying to keep this focused on the exemptions and the purpose of the ORAD mapping. But I would draw your attention to my summary on pages 9 and 10 of that critique. Almost all of those comments stand. My comments are basically looking for standard notice of intent information, which this plan does not provide. And I would wind up my comments by noting that the purpose of the 100-foot protection around a vernal pool, both in the Wetland Protection Act and particularly in the bylaw, is to protect the species that are dependent on that vernal pool. And you guys know that, but the species come and go. They use the vernal pool for a very limited period of time. It goes a week, sometimes as much as 2 weeks, but then they mature. In this case, wood frogs leave the vernal pool itself and go back up into the uplands. And they travel anywhere from 100 feet to as much as 800 feet throughout adjoining areas. Because the pond is nearby, and stands as a water source, which would not be the case once the vernal pool itself dried up, it's very likely that the frogs use the property beside the old cabin as a migratory path. We don't know because the applicant hasn't conducted the usual analysis to make that determination. But that's the purpose of what the bylaw is attempting to protect. It's looking out for the critters that live in those areas. So I think you need to keep that in mind. This is not just about how the extent to which we can develop within that area, but its driving purpose is protecting the vernal pool itself. So thank you very much.
Thank you, Mr. Garner. Mr. Bowen?
Okay, hi. Thanks, Mr. Chairman. I'm getting old and I can't handle these long meetings, but I just want to make 2 points. One, I emailed the commissioner a letter today, which basically referred back to the January 23rd hearing, the section of the hearing, and the agent at the time and commission members made certain requests to the owner, to the developer, on things that they wanted to see, either, I guess, independently or on the plans. And I don't know if all that is still relevant after tonight's discussion, but I don't think that they were actually addressed. The other issue that I want to make is that I was sort of discouraged with your comment that we don't want to look back because we can't verify certain things that might have happened or might not have happened. If you look at the whole scope of things, I'm actually the only one in the area that's been there for an extended period of time. We went there every summer, so you see the development, and that could comment on what was there, what wasn't there. Now, obviously, there were things that came about after the current owners bought the property, like the raking of the lawn and everything, which is nice. But if we're going to talk about the condition of the property before 2007 or even before 2021, actually before 2021, well, there's only a couple people that know that, and that's the owners and me. Before 2007, basically, I'm the only one around. So I don't think, and I Jeff mentioned this, that you can ignore me. Well, you shouldn't ignore me, but you can just dismiss what I say because it can't be verified or substantiated because I don't have pictures. And actually, one of the pictures that was shown was the comment about the tree, and they drove around the tree. Well, I guess my question would be, who drove around the tree. If you're gonna say that we can't verify, then why was it even brought up that somebody drove around the tree, whether it be for 10 years or for 2 years? And so I don't think you can isolate what the past was if you're looking for when things happened from reality. My initial job here tonight was to set up Jeff and Pat, but they obviously did a great job themselves. So, thank you for your perseverance. I'm going to bed.
Thank you, Mr. Bowen. And I apologize. So what I was trying to emphasize to Dennis was that we need to not do speculation. I recognize that you provided testimony of your personal observations. I apologize. I didn't mean to
Why do I put my hand up?
say that your observations were inaccurate.
Yeah, I understand.
I don't know how to put my right here. No, that's chat.
So I hear you, Chris. You're talking. You go ahead.
Hi, Tom. This is John Quill. I'm Jeremy's father, and I have a couple points I think I'd like to bring up that hasn't been brought up at this point. We just heard from two of Mr. Bowen's people. Next to the house where the gravel area is a septic system. Jeremy and Nicole didn't put that in. It was pre-existing when they bought the house. So it had to be disturbed to put a septic system there. And that's why the gravel is there in that picture. And Attorney Roloff said, this is an undisturbed area. How can that be if there's a septic system there? It has to be. And there's a few people making some exceptions that are just not true. And the whole thing about landscaping and yards and lawn, you just have to look at Mr. Bowen's property. He'll be happy to confirm he has no lawn on his property. It's exactly the same as this property. It's a summer camp type property. The other thing on that one is, pretty much what I had to say on that was the septic system is there and the property, there's a sauna down by the water. There's a picnic table. There's a beach. Obviously, the people that previously owned this property used that way. They drove down to unload their boats and launch their boats. They used that property as a thoroughfare for, 100 years or so to get back and forth, or pre-existing before Jeremy and Nicole owned it. So there's a lot of assumptions here that just don't hold water. This property was lived on. It was used. The pictures that the attorney showed that with some growth around the housing, sure, the individual that owned that property had passed away and the house sat idle for a year. Well, it was being sold. So granted, weeds and stuff grew up around that property. Those photos are completely misleading. I think the commission should take that into consideration. Some of this stuff is just misleading. And of course, especially with the attorney saying it's not a disturbed area, how did the septic system get there? So that's all I had to put in. Thank you very much.
Thank you.
Through the chair, if I may, I have one thing that we could actually address tonight, and that was Mr. Bowen's comments relative to whether the plans were updated. The plans were updated to differentiate between the Lancaster buffers and the Mass DEP buffers. That was the request that the chair had made at one of the previous meetings. So yes, that information has been added.
And just as a additional clarification, when the former agent had asked for some of the information that she had asked for, she was under the belief that both of those, the vernal pool and the wetland A, were regulated under the Wetlands Protection Act. So some of those concerns that she had were moot. But for sure, we will get to all of the requests if we can get past this initial issue of exemption. And so with that in mind,
Mr. Chairman, can I respond to Mr. Quill's couple of comments about the property?
So
just two.
I will. Sure, go ahead.
One was the road, the sort of the path down to the beach, the people used it for 100 years to put their boats in. Actually, Mrs. Lottie, who lived there my whole life, I think she died in like probably 2000, never had a boat. So she wasn't going back and forth to put the boats in. And my father spent a lot of time putting a lawn in on our camp. We just let it overgrow. But it certainly doesn't look anything like the undergrowth of the I get the locust.
Okay,
Two
thank you, Mr.
comments
Bowen.
that really have nothing to do with the whole thing, but they just show when someone comes in and makes a comment that they have no knowledge of, it can go out of hand.
Okay, thank you, Mr. Bowen. So, commissioners, I think we need to come to a conclusion on this discussion so that this process can move forward. We need to decide.
Tom, John Quill, could I just comment on that, please?
So I'm sorry. I'm
Tom,
not
could
gonna,
I just, because when Jeremy bought the property, it was 5 boats on it.
Okay, so I'm sorry, but I will not take any further comments on this back and forth. This was what I was trying to avoid when I was talking about history. This is just going to be he said, and I don't want to entertain that discussion. Okay, so commissioners, start this whole conversation about the exemption. You've heard a bunch of testimony. You've heard from the attorneys. So I guess my first question is, do you want to think about it, or do you want to simply say whether you think the exemption applies or not? I think that it's fair. With the applicant's permission, it might be okay to have 2 weeks to think about all the arguments that you've heard. I don't know if the applicant is willing to grant us that 2 weeks, or if you guys are, if commissioners, if you're ready to simply say to what extent you think these exemptions apply today, and you don't need to think about it any further, and we can just move on from that point. Jim, I see your hand up. Go ahead.
Thank you. So for me, I think there may be some areas, like as I said before, that are exempt. Maybe others are not. But I think we need to be very deliberate and specific and clear about defining what is exempt and what is not. And I don't believe we were previously. So in my mind, the intent was to do that as part of the NOI process. So I'm still willing to consider what is exempt and what is not exempt, but not with what is before me right now.
Okay, thanks, Jim. I'm actually going to poll the commissioners. Dennis? Sorry to put you on the spot, but I'm going to want to hear from everybody.
No, I've got a similar taking. I think there is areas that are exempt in my mind. There's some other areas where I haven't seen enough evidence to claim that it's exempt. So if I have to vote right now on the overall site, that's kind of where I'm leaning. But I do think with some further delineation, there's definitely exempt areas within the plan.
Great, thanks, Dennis. Bruce?
So Tom, what are your thoughts when it comes to I think Mr. Garner did an amazing job explaining everything and kind of going through how, and this is the way I thought at the time that we were approving the ORAD, is that we were just approving the delineation, not that it was going to trap us in not being able to protect the vernal pool. And so I guess my question is, do we still have that ability to say that we don't think that those areas our lawn and landscape, can we still put in the vernal pool provisions, or have we already gone beyond that? What's your thoughts on that, Tom?
Yeah, I mean, so that's the crux of the issue, and I need to answer that question for myself also.
Hey, Tom.
I'm sorry, just let me finish, please.
Yep.
So let me pose the two extremes, okay? And I think this will help clarify the issue. On extreme one, the applicant's position is that the red line outlines the limit of disturbance. If you take that to its logical conclusion, not only does it define the area of the vernal pool that isn't jurisdictional, it actually defines under 215-5A that all of the red line is completely unregulated by the bylaw and regulated only by Wetlands Protection Act. I think that's the logical conclusion of the argument that they're making. So if I were to accept at face value that the shaded area shown in Exhibit 3 earlier was truly entirely exempt, then I'm basically granting that the entire project is exempt from the bylaw as drawn on the plan submitted earlier this year, because it has just a minor, there's just the outer buffer zone incursion under the Wetlands Protection Act. So that's extreme number one. That's the most beneficial to the applicant. On the flip side, the most extreme, benefit to the town would be that the red line has no meaning under law, that we didn't delineate either exemption 215.5, 215.3, and that all that we approved in the ORAD was simply the delineation as has been advocated by Mr. Garner. So that's the other extreme. In that extreme, I look at this plan and I say that it's completely unpermittable for so many reasons. 25-foot no touch incursion. It's entirely within buffer zone. No attempt has been made to reduce the impacts on the resource areas. And even, it's both vernal pool, resource area, but also buffer zone to wetland A, wetland C. So this plan's an utter non-starter for me, right? This would be just no, not redeemable. So those are the extremes, okay? I think Mr. Hannigan was trying to redirect us to finding a middle ground between those two extremes, to find a way to begin the discussion on how to make this plan more agreeable to the commission, and also agreeable to the Quills, so that they could, build closer to the pond, which is clearly their intent. You'll notice that I didn't tell you how to think, because I also don't know how I think. I will tell you that at one point in time, I was at both ends of those extremes in my thought process. I'm personally open to having a discussion about how to minimize the impact and still leave a structure here. I'm open to that discussion. But that discussion would be, in my mind, would be grounded in the fact that the exemptions do not apply for the majority of this area. Sorry, not the majority of this area, but certainly for some parts of this area. I think the exemption clearly applies to the driveway. In my mind, the driveway is a developed area. The driving around the tree, I don't know about that, quite frankly. Just because someone drives through a forest doesn't make it developed. I think that's kind of an extreme argument, but I'm not a lawyer.
Thank you, Tom. I agree with you. That's like right where I am. I'm in that spot that you are in.
So I don't know if that was helpful to you guys.
No, it was. I mean, I think that I think that we should have all avenues available to us. I don't think we should be excluding that vernal pool, but we're always willing to work with applicants. And I think we should continue this process and listen to what they have to say. But I don't think we should be handcuffed on being able to you know, use the vernal pool as an area that we can't touch because it's considered developed. I don't think it's developed enough for that exclusion. So I agree with you, Tom. I think we should be able to listen to the applicants and see what they'd like to do on building and see if we can work with them on something that's reasonable. But I don't think we should accept the exclusions.
Yeah, so I'll be honest though, Bruce, if we were to say that this entire red dash line means nothing and that the site is not really developed other than the structure that exists, I would find it difficult to have a discussion about placing a very large structure here. And the reason why
I'm in the middle road. I'm in the middle road with you. I don't think that we should completely go by where they put all those red lines, but I agree with you. There is the driveway. There are certain areas, but I'm kind of in that middle road.
Well, so let me finish my thought. So,
Sorry.
The general guidance from DEP is that when you're looking at a notice of intent, you shouldn't just take what's given to you and allow alterations, to some limit, but seek to improve the conditions. If I look at this and I say, have I improved the conditions? The answer is absolutely not. In fact, there's 11 acres that are completely outside of jurisdictional areas. I look at this plan and I see someone, doesn't care about the resource areas at all, and is using, the maximum amount of area possible within the boundaries of the exemption. Now, if the commission decides that the exemption applies, well, that is their right, and this plan is, it's hard to argue against this plan. So again, I'm just talking in hypotheticals.
Thank you.
Go ahead, Dennis.
I was just going to ask, I was looking through the plans we have, and it was mentioned a couple times on the call tonight that septic is to the right of the house. And I haven't seen any plans with that. Does any of the other commissioners here, have you seen plans that show where the historical the current septic is? Because to me, that would be developed area if we put a septic there, right? So that kind of extends that line a little bit.
I'm looking at the ORAD plan.
I didn't see it, but I might have missed it.
Through the chair, I think
Sure, go ahead.
we would have to go out and locate that. I don't know exactly where it is, but I'm sure that we could. I'm sure there was I presume that there was Jeremy, was there a Title V done on the property before you bought it? So there would be some record somewhere. I know it's not a compliant system, but at least we'd know where it is. We could provide, I guess when it comes down, we could probably provide that information. Right now, yeah, you have hearsay that it's there. Let's prove it out.
Let's prove it out. Yeah.
Yeah.
So I don't know that we've reached any final conclusions. I'm certainly open to seeing what plan alterations could be made to reduce the impacts. Under the assumption from my part that the exemption largely do not apply, because I don't consider much of this to be developed. So that's my perspective. I'm open to having further discussions about minimizing the impacts, but I don't recognize this red dash line in its entirety as exempt from regulation under the bylaw. That's where I sit.
I agree.
Bruce agrees. Jim
I agree.
and Dennis?
Not in its entirety. No.
Okay, so Bill, I think that you were looking for some more clarity. I don't know if we've provided you any more clarity, or if you think that that's not satisfactory result.
No, I think every step forward is a step forward. So we had to go through this discussion tonight to get to the next level. I think what we'd like to do is request that the commission continue this hearing to the next meeting, to allow us to talk internally about the approach. I would also ask permission to reach out to Brad and kind of review some of our thoughts with him, relative to potential different directions of where we could take this if it's acceptable to the applicant. But there's been a lot of discussion tonight. I don't know what the position of the ORAD's how that's gonna play out. But I think that we need to go back and kind of have a discussion about this and kind of come up with potentially some ways that maybe we do something. I have to talk to Attorney Nyland about what I can say and what I can't say.
Sure, understood.
So regardless, I think what I'll do is request a continuance, and I'm not sure where the next meeting is.
I believe it's July 9th. Well, let me close that window. Where is it? Yeah, our next meeting is July 9th. I think you're looking at your calendar while you're doing that.
Oh, look at that.
One more
Everyone can see
person
my
with their hand
calendar.
up. Well, I can't see your calendar, but since you were not saying anything, I assumed you were looking at your calendar.
Yeah, okay.
I think
Yes.
Jesse St. Laurent or St. Laurent. Sorry, I don't know how to pronounce your last name. Go ahead.
No worries. Either way is fine. So I also live on Fort Pond and have a question for the commission in terms of how this rule or exemption is interpreted. Because in terms of the charter of the commission for the betterment of the species and protecting the environment around the ponds, the way I hear the discussion this evening is if this type of exemption is possible, then anyone with a beach can build a cottage essentially at the water line. And for several properties on because that's a beach following the same logic that this evening would be considered an area that's been somehow maintained or not in its natural state anymore. Additionally, there are folks who have lawns, there are folks who have other areas that are directly on the water. I actually have a fairly sizable beach with an adjacent area next to it that is mowed and is partially a driveway. I never would have expected that I could build a house there on my lot. I suspect most folks in the pond don't anticipate that they could build a cottage on their beach. And to my recollection, there's been some pretty uncomfortable conversations and in previous discussions with the board when cottages or even small adjacent buildings were constructed directly on the water that led to kind of long-term complex relationships around those decisions. So I would ask if this is the interpretation of my understanding that right, which is I can go build I can turn a beach into a house if this is interpreted in this way.
No, so you're missing an important complexity on this project is that largely this project is bylaw only. So it's not clear from the plans, or not very clear from the plans, but this is largely outside of the jurisdiction of the Wetlands Protection Act, so the state level regulations. State level regulations would prevent you from building a house on a beach, because that would be within the 100-foot buffer zone to the pond. The structure being proposed here is, while it's within the buffer zone to state regulated resource areas, the discussion is largely about the town regulated resource areas and whether it's exempt or not from the town regulation. We're not having a discussion relative to the state regulations. These wetlands that are adjacent to the proposed structure are not regulated under the state regulations. So if they were regulated under the state regulations, we wouldn't be having this conversation at all.
I see. So the 100-foot lake buffer zone that's typically applicable is not applicable in this instance. It's okay to build inside.
It is applicable, but only barely. The proposed structure is on the outer edge of the buffer zone to wetland B and also the pond. So it is regulated under the state, but only a small portion. Only some of it. The key discussion here is about the rest of it relative to the locally regulated resource areas.
When I look at the plan, they did 319. I'm only grossly estimating because I'm just looking at it on my screen, but I would say half of the square footage of building or more is inside the 100-foot lake buffer zone.
Yeah, so I misspoke. I thought the line was a little closer. So you are right. It's about half the structure, but the performance standards for the state regulations are also different. So while it would still be regulated, and there would be a discussion, really the way the commission views this project is going to be driven largely by the bylaw. Because the bylaw impacts are much more significant than the state impacts.
Well, once those bylaw decisions are made, is there then discussion around that 100-foot buffer zone for the state considerations?
For sure.
I know that certainly new construction around the house, and certainly my approval to build was based on getting no closer to the water measured to the foot than the existing structure. And I know neighbors that have built have not been able to get a foot closer, and the immediate neighbor to me was held to a 100-foot distance and had to adjust their plans multiple times to stand clear of that 100-foot area. Those were previous decisions from the Lancaster Conservation Commission.
Yep. So we haven't really reached that point in this process. Today was really just about understanding, how the exemptions of the bylaw are going to apply to this project.
Okay, thank you. I appreciate you taking the time to clarify.
Right, Bill. So I think you've had time to review your calendar. Is July 9th okay?
Yeah, that's fine.
Okay.
I'll make a motion to for continuance to July 9th.
I will second, Dennis.
All right, motion's been made by Bruce and seconded by Dennis to continue to July 9th. Any further discussion? Seeing none, this will be a roll call vote. Dennis Hubbard.
Aye.
Jim LaValle.
Aye.
Bruce McGregor.
Aye.
And Tom Seidenberg also votes aye. Thank you, everyone. Thank you for lasting through the long discussion.
Thank you for everyone. Yep.
All right, next up on the agenda, we have a continued notice of intent for McGovern Boulevard. I believe we have a continuance for this. Is that correct, Brad?
Yes, that's correct, Mr. Chairman. We did get that request this afternoon.
Do you know when they wanted to continue to?
Me double check on that. I believe it's the next meeting.
Okay.
I'll just confirm in 1 second.
Yep.
Yes, July 9th.
Can I make a motion to continue to July 9th?
Second.
Motion's been made by Jim and seconded by Bruce to continue this hearing to July 9th. Any further discussion? Seeing none, roll call vote. Dennis Hubbard.
Aye.
Jim LaValle,
Aye.
Bruce McGregor.
Aye.
Tom Seidenberg also votes aye. Next up on the agenda, we had Lancaster branding and wayfinding signs draft report. Sadly, Claudia had to leave. Yeah, Claudia LaFontaine. So I guess we will pick that up at another meeting. Next up on the agenda, we have a request for an extension, DP 193-0589. Brad?
Yes, we did receive a request to continue that as well to the July 9th meeting.
Okay.
I guess point of order does that need to be continued?
Yes, there's a time limit on granting extensions. Is there? There's certainly a deadline.
Yeah.
Just refresh my memory, Brad. This is for the water main extension?
That's correct.
Okay. And when is it due to expire?
Sometime in October.
Okay.
I don't remember the specific date, but I know the applicant's representative and that was one of the questions I had. I wanted to make sure that there was ample time, should something happen the next meeting and it got postponed again, it wouldn't have expired in the interim. So it seems like there's plenty of time. They did want to be present for that discussion at least. So I think the continuance request would be fine.
Okay. Let's just do motion and vote on it just for clarity.
Okay. Motion to continue to the 9th of July.
I'll second.
All right, motion's been made by Jim, seconded by Dennis to continue the discussion for OOC extension for 193-0589. Any further discussion? Seeing none, roll call vote. Dennis Hubbard.
Aye.
Jim LaValle.
Aye.
Bruce McGregor.
Aye.
Tom Seidenberg also votes aye. Next up, we have open seat on the commission. So I do have to make a slight apology here. While I was away on vacation, the appointments did come up. Two appointments, two people had volunteered for the commission, and their appointments went before the select board, as well as Bruce's reappointment. So Bruce had accepted reappointment so that the commission would continue to have 4 members while we had an empty seat. And because I was on vacation, I didn't notice the agenda for select board, and I wasn't able to let them know that the idea was to appoint the 2 new people and not reappoint Bruce. So Bruce got reappointed and Dave Millett got appointed. I don't understand why Dave Millett didn't get appointed with immediate effect for the empty seat, but my understanding is he was appointed to start his term in July. So when I got back from vacation, I did email Chairman Kerrigan of the Select Board to ask the Select Board to reconsider Mr. Fawcett's interest in the commission. I don't know if Mr. Fawcett is still interested in the commission, but I'd be happy to have him if he is. And hopefully that would lead us to have a full board again in July. So that's the update. I do expect us to have a full board, if not the first meeting of July, hopefully by the second meeting of July, assuming that Mr. Fawcett wasn't offended that he wasn't picked amongst the 2 new appointments. I hope that he wasn't. I did apologize to him as well for the snafu. Yeah, sorry about that. And I guess in that same vein, I'd like to publicly thank Bruce for all of his efforts the last few years. It's been a pleasure to have you on the commission. I'm really going to miss your contribution. So thank you very much.
Yeah.
Thank you guys. You guys have been wonderful to work with, and I've loved being on the commission the last 3 years. So thank you very much. Appreciate it.
Yeah. Good luck, Bruce. Sorry to
Thank
see
you.
It's been good having.
Thanks.
Best of luck, Bruce.
Thank you.
And then we have minutes to approve. I'm sorry, I don't remember seeing any minutes. And anyway, I wasn't at 2 of those meetings. Did we have minutes?
Yeah, they're on the website.
Oh, okay.
I didn't see the June one. I saw the 2 May ones. I've got my dates.
Just those two, we have May 14 and May 28.
Yeah, I saw those 2.
So I'm happy to take comments on any edits and or motions to approve. I didn't review the 514 minutes. So
I'll start with a motion to approve the 5/14/2024 meeting minutes.
Second.
all right, motion's been made by Dennis and seconded by Jim to approve the May 14th, 2024 meeting minutes. Any further discussion? Seeing none, roll call vote. Dennis Hubbard.
Aye.
Jim LaValle.
Aye.
Bruce McGregor.
Aye.
And I will abstain since I didn't actually read them. So, sorry about that.
Make a motion to approve the 5/28/2024 meeting minutes.
Yeah, I second that.
All right, motion's been made by Dennis, seconded by Jim to approve May 28th. Any further discussion? Seeing none, roll call vote. Dennis Hubbard.
Aye.
Jim LaValle.
Aye.
Bruce McGregor.
Aye.
And I will abstain also from this one since I wasn't at the meeting. And June 11th, there was not June 11th?
Did not see them.
Okay.
I didn't see that one. Brad, you confirm?
No, I don't believe that one's been done. I've just for informational purposes, I've been putting those dates on the agenda just in case, Roz is able to get them completed, shortly after we have to post it, for instance. I want the commission to have the ability to be able to make a decision on it, but those June ones have not been done yet, to my knowledge.
Okay, thanks, Brad. So that completes our agenda. Sorry for the late meeting, gentlemen. But I think that's it. Does anyone have anything else today? All right, then I think I'd be happy to take a motion to adjourn. Oh, sorry, one more thing. Bruce, did you have something, or you were going to offer the motion?
No, I was going to make the motion to adjourn.
Okay.
After you do.
So at the next meeting, I think we'll do the vote to reorganize since we'll have the new term starting, and it's traditional to reorganize after a town meeting. So we didn't do that last month since I was away. So I think at the next meeting we'll reorganize the board again. And now I think we're ready for the motion.
I'll make a motion to adjourn.
I will second.
All right, motion's been made by Bruce and seconded by Dennis to adjourn the meeting. Any further discussion? Seeing none. Roll call vote. Dennis Hubbard.
Aye.
Jim LaValle.
Aye.
Bruce McGregor.
Aye.
And Tom Seidenberg also votes aye. All right, thank you, everyone.